Please call the case.
Thank you, Your Honors. Good morning, Your Honors. Good morning to everyone in and around the courtroom. This is case number IT-0481T. The prosecutor is Momčilo Perišić. Thank you, Your Honors.
Thank you very much, Mr. Registrar. Could we have the appearances, please, starting with the prosecution?
Good morning, Your Honors. Good morning, counsel. Good morning, everyone in the courtroom. Mark Harmon, Barney Thomas, Brona McKenna, April Carter, and Rafael La Cruz, and Carmela Javier for the prosecution.
Thank you very much. And for the defense?
Good morning, Your Honors. Good morning to all the participants in the proceedings. Mr. Perišić is represented in court today by Mr. Gregor Smith, Novak Lokic, and then our co-workers, Chetner Ditmotgore, Tina Dolitz, and Boris Zorko.
Thank you very much, Mr. Lukic. May the chamber please move into private session.
We're back in open session, Your Honors.
Thank you very much, Mr. Registrar. Now, Mr. Harmon, prosecution final brief. Is the prosecution charging the two modes of liability cumulatively or alternatively? I'll tell you why I'm asking. Asking because up until we received the final brief, I had been under the impression that it is cumulative. However, at page 294, paragraph 808 of your brief, for the first time I see the phrase in the alternative.
Your Honor, we're charging General Perišić cumulatively. The court makes a finding on 7-1 of guilty, then we say that it does not have to make a finding in respect of 7-3.
Having given that answer, and my next question then becomes, what actually, and I see it's not the first time in the tribunal that this is done, what is actually the rationale for charging cumulatively two mutually exclusive modes of liability?
Your Honor, we usually charge cumulatively. The courts have made decisions that have suggested that if in the event there is a conviction on 7-1, it does not have to make a finding on 7-3. We have charged it cumulatively. The court has the discretion then to make a finding on either 7-1 or 7-3.
Okay, I'm going to start again, Mr. Harmon. I did say at the beginning, I've seen that it is done in the tribunal. I've seen it in the courts. I have not found any legal justification, legal explanation why it must be the court, which is not the dominus litis, which must choose which one to convict on. And I understand that it is being done, but all I'm asking is, what is the rationale? What is the legal reason for doing this? Because, as you've just said, it is the court has discretion then to make a finding either on 7-1 or on 7-3. The court is not the dominus litis.
Your Honor, both modes, both ways of charging General Perišić are proper and correct. We have asserted both modes, both 7-1 and 7-3. I think, Your Honor, I do believe there are different types of liability. The first is...
Maybe I have not, I'm being unfair on you. my actual question really is why charge both modes of liability, which are mutually exclusive, for the same conduct? You see, for the same conduct, you are saying under 7.1, you are a perpetrator. Under 7.3, you're saying, I acknowledge you are not the perpetrator, these are subordinates who are the perpetrators. But it's for the same conduct.
They address different issues, Your Honor. One addresses the issue of General Perisić's responsibility as a commander for the actions of his subordinate, and we assert that he is responsible. The other method, the other charge under 7.1 is that he assisted in the crimes. We assert that's we assert that's proper. I can't give you a legal justification, Your Honor. I can tell you that we have asserted both.
The problem is, if they are charged in the alternative, then there's logic in the whole indictment. But if they're charged cumulatively, I don't see the logic of the indictment. And if you charge them in the alternative, you'll still get what you get if you charge them cumulatively, because you say, as you say, that if you convict on the one, you don't bother on the other. So the end result would still be the same, but I just don't find, if I had been in the pre-trial of this case, I wouldn't have accepted this kind of indictment, even though it has been done before in this court.
Your Honor, we have been proceeding for over 3 years on this indictment in the way in which it's been charged.
I couldn't ask this question during the trial, and I didn't have the opportunity at the pre-trial phase. I'm asking now at the beginning of the final brief, of the closing arguments, because this is the only opportunity I thought was appropriate.
Well, Your Honors, as I said, we have charged it in both respects. In our brief, we said, no, alternatively, we accept the decision of the courts, and we are proceeding on the decision of the courts and the logic of the courts to proceed in this way. If there is a conviction on 7.1, the court doesn't have to make a finding on 7.3. Of course, Your Honor, in respect of the charges in Zagreb, the only charges against General Perišić are 7.3.
That's fine. That's a different consideration. Okay, thank you very much, Mr. Harmon. I just wanted to raise this issue, that it has caused me concern right through the trial. And you may proceed with your argument.
Your Honor, I'm sorry I haven't given you the satisfaction of an answer that addresses your concern, but it's the way we have been proceeding, and I can make no further submissions on it. Your Honor, this is the prosecution's opportunity to make its closing submissions. This case started on the 2nd of October 2008. Before I begin with the substance of my remarks, many people participated in the conduct of this trial to bring it to this stage, to this conclusion, and I'd like to take a minute to acknowledge and thank those people who made contributions. First of all, Your Honors, I'd like to thank you, Judge Maloto, Judge David, and Judge Picard, for your patience, for your understanding, and for the dignity in which you conducted these proceedings. I thank you also for the courtesy which you showed the witnesses when they appeared, and you showed the parties during their conduct of these proceedings. I would like to thank the Office of the Prosecutor trial team, it's both past and present, its investigators, its support staff. I'd like to thank the defense, Mr. Lukic, Mr. Guy Smith, Mr. Zorko, Mr. Mayer, Ms. Drolik, and previous counsel, Mr. Castle, with whom we have had an excellent working relationship throughout this case. I'd like to thank the legal officers, Mr. Blumenstock, Mr. Moneta and others who were of great assistance to us and to the defense, I know, who were always available to us and participated in a constructive way in this case. The registrar and the many people from the registrar who have appeared in this case need our thanks as well. They managed large volumes of documents very effectively, and we're quite appreciative. To the interpreters who we bedeviled for probably 3 years, sometimes speaking too fast, I think they have one of the hardest jobs in this institution. I'd like to thank them. They have impressed me over the many years I've been here, and they impressed me in this case as well. We owe thanks to the translators from CLSS and from DVU, who were confronted with large volumes of documents, literally thousands and thousands of pages, and their work was impeccable. The people in the technical booths as well need expression of appreciation, because there are many times in this 20th century courtroom, or 21st century courtroom, I should say, where things broke down, and without their assistance we could not have proceeded. The security people were, of course, quite helpful. And finally, the victim and witness unit that assisted both parties with the management of the witnesses. So I would like to express our gratitude for the very excellent assistance we have received throughout this trial. Now, Your Honors have received our extensive trial briefs. Your Honors were kind enough to grant our request to make these briefs longer than normal. The parties avail themselves to that. We do not intend, the prosecution does not intend to repeat the contents of its brief. We certainly rely on the briefs. We will be making submissions in respect of certain elements of the briefs, but we will be not repeating their contents entirely. We rely on them. Of course, we're available to answer the trial chamber's questions. In making our submissions, Your Honor, we will be having to go into private session on occasion because of the confidential nature of some testimony. We intend to minimize that. We've made efforts to make that as unobtrusive in these final submissions as we can. Now, Your Honors, in assessing the evidence in this case, the trial chamber must view the evidence as a whole, both direct evidence and circumstantial evidence. Circumstantial evidence forms a significant part of the prosecution case, and the prosecution relies on inescapable inferences drawn from the evidence as a whole to support each of the elements of the offense. In this respect, Your Honors, the defense miscalculates the prosecution case. Throughout the defense final brief, the defense isolates individual documents or categories of documents and argues that each is either insufficient or so unreliable to be considered as supporting the prosecution case. However, in our view, that approach is flawed when one considers the nature of circumstantial evidence and the burden of proof. Such evidence should not be viewed and evaluated in isolation, but assessed against the totality of the evidence. Like any body of circumstantial evidence, inferences are available from the whole that are not necessarily provided by pieces of evidence singly. Your Honors, the prosecution intends to divide its presentation in the following way. I will start by making, not submissions, but giving Your Honors an overview of the case. Ms. McKenna will make submissions on the law and on the personnel centers. Mr. Thomas will make submissions on aspects relating to logistics. Ms. Carter will make submissions relating to Sarajevo, which will touch upon the VJ participation on Mount Zuch, the campaign of sniping and shelling in Sarajevo, and unscheduled incidents. And I will conclude, Your Honor, by making submissions on General Perisić's responsibility under Article 7.3 and with sentencing submissions. The prosecution has charged General Perišić with 13 counts. He's charged both under Article 7.1 and 7.3 of the Statute of the Tribunal. And in respect of the crimes in Sarajevo, Your Honor, he is charged with 2 counts of murder, one being a crime against humanity and one violation of the laws or customs of war. He is charged with 1 count of inhumane acts as a crime against humanity, and he is charged with 1 count of attacks on civilians as a violation of the laws or customs of war. In respect of Zagreb, the rocket attacks on Zagreb, we have charged General Perišić with 4 counts, but under Article 7.3 only. He's charged in respect of Zagreb with 2 counts of murder, crime against humanity, and a violation of the laws or customs of war, 1 count of inhumane acts, injuring or wounding civilians as a crime against humanity, and 1 count of attacks on civilians as a violation of the laws or customs of war. In respect of Srebrenica, we have charged General Perišić with 5 counts under both Articles 7.1 and 7.3. He's charged with 2 counts of murder, a violation of the customs of war, a crime against humanity. He's charged with 1 count of inhumane acts, that is, inflicting serious injuries, wounding, and forcible transfers as a crime against humanity. He's charged with 1 count of persecutions on political, racial, or religious grounds as a crime against humanity. And he is charged with 1 count of extermination as a crime against humanity. The modes of liability under Article 7.1 is aiding and abetting. Now, I want to clarify our position in respect of General Perisić's 7.3 responsibility. General Perišić is charged with, under Article 7.3, with failure to prevent his subordinates for having committed crimes in Sarajevo, Srebrenica, and Zagreb, and for failing to punish his subordinates for having committed those crimes. In respect of the crimes in Zagreb, the prosecution is not seeking a conviction of General Perišić for failing to prevent the crimes committed in Zagreb. Now, Your Honors, and this is for the benefit of the public and not for Your Honor's benefit or for the benefit of my friends from the defense, we will be using throughout our submissions a number of acronyms, and in order that the public understands what we're talking about, I will identify those acronyms and explain what they mean. When we use SFRY, we mean the Socialist Federal Republic of Yugoslavia. When we use FRY, we mean the Federal Republic of Yugoslavia. We will use RS, which means Republika Srpska. We'll use RSK, as Republika of Serbian Krajina. JNA means the Yugoslav People's Army. VJ means the Army of Yugoslavia. VRS means the Army of the Republika Srpska, and SVK is the Army of the Serbian Krajina. Now, Your Honors, the crimes that in Sarajevo and Srebrenica that the trial chamber has been examining were the foreseeable consequences of state policies encouraged and promoted from Belgrade. Those policies were implemented by military force and in the process of implementing them, the lives of ordinary men, women, and children were devastated. Some people resisted the ferocious onslaught that endangered their lives, the lives of their families, the lives of their fellow citizens. Many did not or could not, only to be crushed and swept aside by forces greater than themselves. They were the collateral damage of state policies. This case addresses the criminal responsibility of General Perišić, who during the period of the indictment was the key military implementer of FRY state policy vis-a-vis Croatia and Bosnia. The indictment identifies a crime base of enormous scale and scope. A campaign of shelling in Sarajevo and sniping in Sarajevo that occurred over a protracted period of time. The forcible expulsions and mass executions at Srebrenica. The Orkan rocket attacks on Zagreb. Now, the manner by which we have endeavored to prove the crime base was by availing ourselves to procedures provided in the tribunal's rules of procedure and evidence, adjudicated facts from other trials. We proceeded by using agreed facts we could agree with the defense. We submitted numerous witness testimonies in written form in lieu of oral testimony, and we also presented some oral testimony from victims. Now, the use of these procedural measures to present evidence clearly streamlined this case. But I offer this observation, and I do not intend this to be a criticism. As we all appreciate, at the core of these cases are people, ordinary people like you and like me, like people in this courtroom, but who have had the misfortune of being caught up in the maelstrom of war and who have suffered at the hands of others. What happened to them, to their loved ones, and to the members of their communities, the public needs to hear. Streamlining cases before the tribunal has its benefits, but the cost in part is that the voices of the victims have often less been heard. They have become muted. The voices of the victims were not entirely silent in this case. The prosecution presented a small number of representatives, victims, to establish the crime base. They testified before Your Honors so Your Honors could hear what happened to them, that the forces, aided and abetted by General Perišić. We are indebted to them for having the courage to come to The Hague to recount what must have been truly the worst experiences of their lives. I'd like to thank them publicly for having the courage and to come here to tell Your Honors about what happened to them. Now, one of the victims who testified was Ms. Ivica Perišić. She was the victim of scheduled incident A8 in the indictment. Ms. Perišić was a Sarajevan. She testified that on the 23rd of November, 1994, after she and her sister had been out for the day looking for food, she boarded a tram. They were returning home. While riding on that tram in Sarajevo, she told you that something terrible had happened to her, something that had changed her life entirely. she was grievously wounded by a sniper's bullet. It tore through her shoulder, shattering bones and severing nerves. She had multiple surgeries to repair her arm, which is now 6 centimeters shorter than her other arm. Ms. Perišić was a civilian. She was 31 years old at the time she was shot. You will recall the testimony of MP 294, who was a victim of the crimes committed in Srebrenica in 1995. He was a farmer, a humble man who, along with his wife, his 2 sons, his daughter-in-law, and his 4 grandchildren, had been expelled from his village near Srebrenica. In July of 1995, they were inhabitants of the UN safe area in Srebrenica. Following the VRS conquest of the enclave in July of 1995, tens of thousands of civilians were forcibly expelled from the enclave. MP 294 and members of his family were amongst them. They were placed on a lorry, but shortly after it left the enclave, MP 294 told you that it was stopped, and that he and other men from the lorry were separated from their loved ones and sequestered in nearby schools. They were abused, and some of them were killed. Members of the VRS then transported them to various execution sites where thousands of men and boys were slaughtered. Few survived. MP 294 was amongst the handful of those who did. He told Your Honors what happened at the Branjevo military farm, where he and other